And welcome back, everyone, for our final and an incredibly important session. Although we divided our conference into little segments, criminal versus civil, clinical versus forensic, it's clear that ethical issues permeate throughout, and every single panel has discussed the importance of remembering that there is an individual at the end of the day whose autonomy and dignity could be impacted by many of these questions that we're raising today in the context of assessing decision-making capacity. And so we are incredibly grateful to have Professor Nina Kohn help us think holistically about these issues. Professor Kohn is the David M. Levy Professor of Law at Syracuse University College of Law and Distinguished Scholar in Elder Law at the Solomon Center for Health Law and Policy at Yale Law School. At the conclusion of Nina's discussion, we will have a little bit of time for questions. But with that, Nina, you have the floor, and thank you for your participation.
Thank you, Andy, very much for having me here. I thank the other summit organizers as well, including Shelley Jackson and Naomi Karp for inviting me. It's really an honor and a pleasure to be joining everyone today. So what I'm going to be doing today is focusing on why the conversation we're having here at this symposium matters so much. And specifically, what I want to do is talk about the consequences, both the legal consequences and the practical ones, that a determination of incapacity has on older adults' lives and on efforts to promote elder justice more broadly. And building on the Associate Attorney General's call for communication across discipline, I will suggest how judges, attorneys, evaluators, clinicians can work together to try to help increase the positive impacts of capacity assessments and reduce the detrimental ones. So at the outset, to understand the consequences of capacity assessments, I think we first need to appreciate the myriad of ways that capacity assessments are used in legal proceedings and in legal systems. So one way capacity assessments are used is they're used as evidence. So a capacity assessment may be evidence in a proceeding to determine whether an individual is responsible for their own actions or can be held to agreements that they have purportedly made. So, for example, it may be used to show that the individual did or did not have capacity to enter into a contract, and thus to determine, okay, is that person bound by that contract? On the criminal side, it may be evidence of whether the individual was capable of having the requisite mental state, the mens rea, to commit a crime, or, say, to waive Miranda rights. A capacity assessment may also be used, though, to determine whether another person is going to be held responsible for certain behavior. So we know that consent is a defense to a wide range of both civil claims and criminal charges. And the result of that is that whether another person is going to be held responsible for harm done to an individual may depend on the capacity of the individual harmed, right? So capacity assessments may be key evidence in a proceeding to hold that other person responsible because their civil or criminal liability may turn on whether that alleged victim had capacity to consent. And capacity assessment can not only affect whether that other person is held responsible for harming the individual being assessed, but also what they're held responsible for and the penalty imposed. So certain crimes will depend on the vulnerability or the cognitive status of the victim, and capacity assessment is evidence of that. And vulnerability or cognitive status may also affect the consequences of being held responsible, like the length of a sentence in a criminal case, or whether punitive damages are proper in a civil case. Capacity assessment may also be used as evidence to determine, well, what rights or powers will an individual have going forward? Some legal powers are triggered by a determination of incapacity. So for example, a healthcare power of attorney, sometimes called a healthcare proxy, is generally only effective if an individual cannot make decisions for him or herself. And so a finding of incapacity will indicate that the agent appointed under this type of document now has the power to make decisions for a patient. And of course, capacity assessment is key evidence in a guardianship or conservatorship proceeding, right? It can be used to show that that individual lacks capacity, and therefore a court should appoint a guardian or conservator to make decisions on their behalf. But capacity assessments aren't just evidence in legal proceedings, they also really shape those proceedings, right? So let me give you a couple examples. A lawyer may want to know about capacity because the lawyer is considering having an individual testify. And they want to know, well, does this individual have the level of capacity needed to testify? Will their testimony likely be undermined by a claim that they don't have capacity to testify? And capacity assessments may also guide decisions about which cases to bring. For example, a determination that a witness lacks capacity may lead a prosecutor to decide not to prosecute because it's going to be harder to prove the case. A determination that a victim had capacity to consent may lead to a decision not to pursue a case for which consent is a possible defense. So these assessments also shape proceedings. But there's a third use I think we also need to recognize here, and that is that capacity assessments can serve as a kind of strategic resource. That is, they may be procured and employed for strategic ends. So for example, a trust and estates attorney who's preparing a will for a client may want to obtain a capacity assessment so that that assessment could later be brought forward should somebody try to contest the will on the grounds that the testator, the person writing it, lacked capacity to actually write that will. So let's step back for a moment. What does the fact that capacity assessments can be used in all these ways actually mean for older adults? What does it mean for elder justice? Well, let me suggest there's a couple of takeaway lessons. One is that it means that a capacity determination may be the difference between whether an individual can make fundamental choices for themselves and whether they can't. It means that a capacity determination may decide whether their rights will be vindicated if they're abused or exploited. And it means that a capacity assessment may affect how others will treat them, whether others will agree to work with them, whether others will enter into contracts with them, whether others will help them to advance their wishes. So to put this in a concrete context, I want to consider a specific context in which capacity determinations can really change the course of a person's life. And it's one we've already heard a little bit about today. It's the guardianship context. So let's for a moment consider an individual whose capacity is assessed as part of a guardianship proceeding, right? So I don't think I have to tell this group that guardianship is simply a common court proceeding in which a court is going to appoint somebody to make a decision for somebody else who the court finds can't make that decision for themselves and is therefore at risk, right? We know that the exact terminology varies from state to state. Many states are using the term conservator to refer to somebody appointed by a court to make financial decisions, and the term guardian to refer to somebody appointed to make personal decisions. But others will use the term guardian to refer to both types of appointment. And the term conservator can also be used to refer to both types of appointment. And Louisiana has its own terminology, curator and tutor. And guardianship is an age-old approach to protecting vulnerable adults. The US guardianship system actually has its roots in statutes passed in England in the 1600s. And even today, guardianship can provide really valuable protection and assistance for people who are unable to care for themselves. So for example, imagine an individual who has a chronic illness, but they can't understand the nature and consequences of that illness, can't understand that even with substantial help. They can't provide informed consent for treatment, and they never did the advanced planning, the type of advanced planning Charlie Sabatino talked about earlier, right, that would be necessary to appoint somebody to make decisions for them. Now, it may be in this individual's best interest for a court to appoint a guardian. And a capacity assessment showing their inability to make some or all decisions may then be absolutely critical to obtaining needed protection. And yet, there's a growing recognition that the guardianship system can also lead to new forms of mistreatment, right? New power and control dynamics, new opportunities for abuse, exploitation, neglect. We know that unscrupulous guardians sometimes exploit the very people that they're appointed to protect, charging unreasonable fees with little court oversight. We know that guardianship can isolate older adults. We know that guardians routinely consent to institutionalization. And that in most states, guardians can restrict access to the person's family or friends with real ease. And even without bad behavior on the part of a guardian, imposition of a guardian itself can create stigma. It can create trauma, as individuals subject to guardianship commonly lose the right to make nearly all decisions for themselves. And Britney Spears, for example, if we think back to earlier, provided heart-wrenching testimony about her experiences under conservatorship and about the trauma of being prohibited from making even very basic choices about her life and her body. But whether a person is subject to this arrangement, one that can be really helpful if truly needed, but which is certainly a double-edged sword, turns in large part on a capacity assessment. And often it turns on a single capacity assessment. And these capacity assessments are unfortunately often at the core of the key problems we currently see with the guardianship system. So let me step back a moment and explain. As I look at it, the guardianship system is really plagued by two very fundamental problems. First, far too often, guardians are appointed where other less restrictive alternatives would meet the individual's needs. And second, most guardianships in this country are full guardianships. That is, these are guardianships that strip the individual of the right to make nearly all decisions for themselves. And most guardianships are full guardianships, even though in many cases, a limited guardianship would meet the individual's needs. Indeed, and there's not great evidence on guardianship, but best evidence suggests that the vast majority of guardianships in the United States are full ones. Sometimes these are called plenary guardianships. What is the result? Well, the result of this is that people who find themselves the subject of a petition for guardianship are likely to be stripped of most of their legal rights, even when this major intrusion on liberty is neither legally justified nor necessary to protect the person from harm. So let me ask you a little thought experiment here. What would it take for courts to stop imposing unnecessary guardianships? What would it require for courts to finally embrace tailored limited guardianships that only remove the rights of a person to the extent that that's really necessary to meet their identified needs? Well, let me suggest a couple things. One is that in order for a court to impose a limited guardianship, the court needs to know a lot more than that a person lacks capacity. The court needs to know what the person lacks capacity to do. Can they make decisions about where to live, what to eat, what to wear, managing finances, all finances, some finances? Could they make decisions without significant adverse consequences about small sums? Could they make decisions if they had appropriate technological assistance or decision-making support? And similarly, to craft a limited order, a court is going to need information not only about what the individual cannot do, but also about what the individual can do. And so an assessment that reports only on deficits and not on abilities does not provide a court what it needs to create a limited guardianship. So what that means is that reforming the guardianship system requires nuanced, detailed capacity assessments. ones that consider not only deficits, but abilities. And it requires capacity assessments that don't simply look at capacity as some sort of holistic single issue. Does the person have capacity? But rather as a constellation of issues. Does the person have capacity to do A, B, C, D, and so on? And under what conditions? And by contrast, if we use capacity assessment tools that look at deficits only, or do not separate out capacity to make different kinds of decisions, or do not consider whether a person can make decisions with technological assistance or support, well, then we really shouldn't be surprised that guardianships tend to be overused and that they tend to be overbroad. And we shouldn't be surprised that Americans are losing rights that they should not legally lose. So what this means is that those called upon to assess capacity in the guardianship context have a really big responsibility. Because if they provide assessments that don't identify abilities as well as limitations, they create conditions ripe for undue and abusive restrictions on liberty. Which is to say, this type of assessment shouldn't be treated as a luxury or merely as a best practice, but as a must-do type of practice. Okay, so let me step back from guardianship for a minute and pivot. And I want to think more broadly about what we as professionals could do to increase the benefits of capacity assessments for older adults and to decrease the negative unintended consequences, and across context. So I believe that if capacity assessments are going to advance elder justice, they really need to do three things. First, they need to be domain specific. Second, they need to apply the correct legal standards. And third, they need to consider both abilities and limitations. So I want to talk about each of those, and let's start with this idea of domain specificity. What do I mean when I say domain specific? Well, what I mean is that a capacity determination must be tied to task. And this is a theme I think we're hearing a lot today. Different tasks require different abilities. And that's true as a matter of biology or psychology, if you will, but it's also true as a matter of law, because the law requires different abilities for different tasks. And the law requires different levels of ability for different tasks. So for example, the level of understanding to enter into a business contract is generally agreed to be substantially higher than that to enter into a marriage contract, which may explain a lot, but I'm going to leave that to the romance writers. Let's get back to the law. The legal standard for a particular type of decision may be very, very specific. Let me give you an example here. Let's take the legal standard for testamentary capacity. Now, a will is only valid if a person, when creating it, had the testamentary capacity to do so. Well, what is testamentary capacity? Testamentary capacity requires a person to know three things and how they relate to one another. First, the person needs to know the nature and extent of their property. That is, they need to have a general sense of what it is that they own. Second, they need to know who are the natural objects of their bounty, which means that at a minimum, they need to know who's in their immediate family circle. And third, they need to understand the disposition being made. That is, how would this will divide up their property? Okay, so now let's think about some questions often asked to figure out if somebody has capacity. Would those questions tell us much about whether a person had testamentary capacity? Well, perhaps not, because after all, testamentary capacity does not require a person to be oriented to time or place. It does not require the person to be able to analyze novel information or remember it. So, as I hope this example shows, if we want to figure out whether a person has legal capacity to make a decision, we have to ask, well, what type of decision is it? That is, legal capacity is domain specific. And that means that whether a person has legal capacity to make a particular decision depends not only on their personal characteristics, that is, their own abilities and limitations, but also on the type of decision to be made. So the fact that a person may have capacity to enter into one type of legally binding arrangement say a contract to sell real property, does not mean that the person lacks capacity to enter into another type of legally valid arrangement, say capacity to appoint a healthcare agent. Okay, so let's turn to the second thing capacity determinations need to do, in my mind at least, if they're going to advance elder justice. And that is, they need to apply the correct legal standards. So let's go back to that testamentary capacity example. Could a reasonable person determine whether an individual has testamentary capacity without knowing what testamentary capacity requires? I don't think so. They would need to know the standard and to assess the individual against that standard. Unfortunately, that's often not so easy because the person doing the assessment may not know what the underlying legal standard is. And sometimes the reason the person doesn't know is that the law isn't actually very clear. Yeah, sometimes there is a particular threshold and it's widely agreed upon, like with testamentary capacity. Sometimes there's a statute that conveniently sets out a standard. But other times the standard is buried in case law and one must comb through court opinions, or if one's lucky, find a treatise or other secondary source summarizing court decisions to find out what that standard is. And sometimes even if you do all that, there'll be no clear standard at all. And in those cases, the evaluator may revert to a default approach, say asking whether the person understands the nature and consequences of whatever the decision is. And that, of course, begs the question of how demanding that inquiry should be and the level of understanding that's legally necessary. What consequences must be understood, to what extent. So that default approach can be a useful rule of thumb, but it's pretty unlikely to result in a reliable assessment of legal capacity that's jurisdiction specific. Making matter worse, of course, as I just noted, these standards are often state specific. So even if you figure out that standard for one state, it doesn't necessarily mean you know the standard for another. And standards change because the law is dynamic, law reform happens. And all this, of course, makes creating standardized tools a real big challenge and perhaps should lead us to be skeptical, at the very least, about claims sometimes associated with standardized tools. So it's critical to apply the correct legal standard, but it's not necessarily easy to figure out what that standard is. So just a shout out to those of you who are interested in policy work and law reform. I think there's a real opportunity here to enhance elder justice through legislation that creates clearer capacity requirements for different types of decisions. Okay, so let's move on to the third thing that I think we need to be focused on here, and that is if capacity assessments are going to further elder justice, they really need to be looking at an individual's abilities as well as their limitations. You know, focusing on limitations is, of course, problematic because it's going to tend to create an incomplete picture of an individual, a picture that is tending to lead to others failing to recognize or appreciate the full extent of the person's abilities, and thus to treat them as a less capable individual than they are. And in considering abilities, a key factor assessors should be considering is whether the individual can make the necessary decision with support, whether that support be technological assistance or decision-making support, such as support identifying, explaining options, right? Very few of us, I hope, make decisions in a complete vacuum. Very few of us make major life decisions without ever consulting others. And so evaluating what a person can do independently without any assistance or social context, and not what they can do with support, is likely to result in a biased account of what that individual can actually do. But focusing on limitations is not only problematic because it creates this incomplete picture of the individual, I believe it's also problematic because the very act of assessing the individual, even apart from any downstream legal consequences, is consequential in and of itself. Having one's capacity questioned and one's deficits probed violates privacy. It can be demeaning. It can be demoralizing. It can be stigmatizing. And it can be downright upsetting for individuals. And it may be scary, really scary. The individual may be aware that the result may have substantial legal or practical consequences for them. Sometimes they may think it has greater consequences than it actually does, too. And moreover, a finding that the person lacks capacity may fundamentally change how others around them treat them and how the individual sees themselves. And so inquiring about strengths, giving people a chance to demonstrate what they can do, not just what they can't, may also help counter some of the dignitary harms associated with capacity assessment. So, what would it take? Another thought question here. What would it take to embrace capacity assessments that are actually domain specific, tied to legal standards, and look at strengths as well as deficits? And let me suggest that the answer is, at least in large part, collaborations. And so kudos to the DOJ for bringing us all together today, working across disciplines, because I think interdisciplinary, cross-disciplinary collaboration is really key here. What do I mean? Well, first, lawyers and judges and others who ask for capacity assessments should be specific in their requests, telling the assessor what the capacity assessment will be used for. And lawyers and judges, especially, should provide assessors with the appropriate legal standards and not, simply assume that they somehow know them or can intuit them, that legal standards come out of the ether. And alas, this is not something we lawyers necessarily do. And I'll be the first to admit I've been guilty of this myself. When I first started practicing law, baby lawyer Indina, if you will, I sometimes was asked to do wills for clients. And my supervising attorney taught me that if my client seemed questionable in their abilities, I should just do what many lawyers did, which was ask the client to get a note from their doctor indicating, yep, this client has capacity. Now, looking at this in retrospect, this approach strikes me as rather unfair to the client and quite unfair to their doctor as well. Me asking a doctor to say whether my client had capacity was me asking the doctor a nearly useless and certainly misleading question, because it was asking the doctor to make an assessment without the necessary context. As a lawyer, if I was going to make that kind of request, at a minimum, I should have told the doctor what decision I wanted to know if the client could make and what my state's law required in order for them to have the legal capacity to make that decision. Equally important, I needed to recognize that the doctor's opinion would actually tell me very little about what my client could do unless the doctor had a reliable way of assessing those specific abilities. But the responsibility does not lie only with those seeking assessments. Those assessing capacity also have a really big responsibility here, in my view. They need to push back when simply asked to assess capacity. And they need to ask, as Charlie Sabatino and Jason Karlowich and others emphasized in their talks today, that they need to be asked a more specific question. Capacity to do what? And those being asked to do capacity assessments need to ask, well, what does the law in this jurisdiction require for a person to have capacity to do that thing? So that is, I would urge those of you doing capacity assessments, when you're asked simply to assess capacity, to be blunt and explain, look, that is a garbage question, and it will likely result in a garbage answer. A more meaningful, a more specific question is needed. And I think this type of pushback can not only improve outcomes for the individuals being assessed, but if enough people do it, it may help change the underlying systems and educate the legal profession and those requesting assessments about what assessments can and what assessments cannot be relied upon to do. Okay, so in conclusion, look, I think capacity assessments are really important, right? They have tremendous consequences for older adults, but those consequences are varied. And indeed, the decision to subject an older adult to a capacity assessment, even apart from the results of that assessment, may have really significant consequences for the older adult's sense of self and for how others treat them. So if capacity assessments are going to promote elder justice and not impede it, they need to be specific to the type of decision at hand. They need to apply the correct legal standards, and they need to consider abilities as well as limitations. And for that to happen, I really do think we all need to work together. We need to set high expectations for the quality of capacity assessments and the completeness of capacity assessments. But we also need to be really realistic about their limitations, what questions they can answer and what questions they really cannot. So what I'd like to do with my remaining time now is open up to any questions or comments that the group may have. Thank you. And Naomi, I believe you may be our question expert.
Naomi, you're muted.
I apologize. So we do have some questions. Some of the questions are more about guardianship and less about the capacity assessment aspect of it. So we may go to those, but let me start with one, which I think you partly answered, but maybe you can expand on it. Someone asks, where do you find the legal standards for capacities? And maybe you could answer this sort of directed more to the non-lawyers in the audience. And maybe the answer is talk to a lawyer or talk to a judge, but maybe you could explain a little bit more about, to the extent that you can find the legal standards, where would one look?
Well, the first thing to do is to ask, what type of issue is it? Now, some types of decisions are governed by statute. And so then your first place to look is to your state statute. Now, note that capacity standards are either coming at you at the state level or at the federal level, not at the county level, not at the local level. This isn't a matter of local practice. Do I recognize that sometimes judges apply things differently in different areas? Yes. But the standard, at the very least, will be uniform across the state. So if you're looking at guardianship, that is statutory law. You're going to look in your state statute. If you're looking at powers of attorney for healthcare or for finances, again, these are governed by statute. So your first place to look is state statute. Not always as clear as you would think, though. And I will just give a shout out to a project the Uniform Law Commission is currently working on, and I have the honor of serving as the reporter for the project. This is the project to revise the Uniform Healthcare Decisions Act. One of the things we're doing in that act is trying to clarify the capacity threshold for an agent to make decisions under a power of attorney for healthcare. But there's other types of domains in which this may be common law, right, which is judge-made law. And so then you're looking at cases. And especially when you're looking at common law-based standards, that's a really good time to be consulting an attorney as to, how do you find that? How do you separate out different levels of authority?
Great. Okay, we have another question. Is there a state or county law that you think strikes the right balance in defining a clear standard, as well as the questions the capacity assessments are expected to answer?
That's a great question. I must admit, I'm really partial to the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act that the ULC has produced with the involvement of many people involved here, that sets a very clear capacity requirement for imposition of guardianship or conservatorship. And what I like about that one And granted, full disclosure, I served as the reporter for that act. But what I like about that is it's a clear functional definition. It ties functioning. It's not a diagnostic-based definition, and it's looking at the combination of what the person can do and risk, and it's defining incapacity in light of supports, not asking somebody to evaluate capacity independent of supports any more than I want to be evaluated for my driving test without my contacts.
Okay. There were a lot of comments about limited guardianships, both during your presentation and earlier. There's a lot of interest in that, and there's a lot of frustration that they are as rare as they are. So this is a very specific question, but I guess it sort of gets at perhaps one of the motivators for not having limited guardianships. What can we say to a guardianship agency that says that in order to accept guardianships for Medicaid clients, they must have full guardianships in order to get payment, especially since the payments are so low?
No, I think is the first answer, right? I mean, there's a lot of things one can do for money that one should not do for money. And removing rights to make fundamental decisions about a person's life from a person capable of making those decisions should just be a hard no. I recognize that there is underfunding, and we certainly need to work together to support these systems. But there should be some hard lines as to what is an acceptable way of going about protecting or supporting agencies that do that.
Okay, we have a question that goes in a little bit of a different direction. Do you think the incapacity language in a lot of trust documents requiring one or two physicians confirming incapacity is appropriate? Do you see other trustee incapacity language emerging? And I guess there could be a sort of corollary to that about, powers of attorney that have to spring later upon incapacity and issues raised by that.
Yeah, I mean, I think there's a really interesting drafting issue for attorneys who are writing trust documents or springing powers to think about whether that term incapacity is sufficiently specific and whether they might want to spell that out. Because remember, when you're talking about something like a trust, this is private law, you're writing your own terms, and you could be more specific about that. Now, maybe the reason you're using a blanket term like incapacity is that you really want to give the trustee at the time a great deal of flexibility. But if your goal is not to allow everything to be loosey-goosey and you really want there to be a reliable trigger of powers, then you might want to think about whether you are more specific. If I'm unable to understand X, Y, and Z or communicate X, Y, and Z even with support, then. And that can make some sense also in the springing power of attorney. One concern that people often have about springing powers of attorney is that third parties won't rely on them because they'll doubt whether the condition has been met or not. And there's a bit of a push and pull whether having a more specific trigger would be helpful there. And perhaps it could be.
Okay, here we have a question that refers to a specific situation, but it asks a pretty big global question.
Okay.
What is suggested to protect an adult if they may have the capacity but make poor decisions? For example, I have a gentleman that I'm petitioning for guardianship for. He has vascular dementia and continues to make poor decisions and not remembering them. He still has some capacity to make decisions, but with his diagnosis, it is felt that he will only decline. I am against taking away elders' independence, but he is a danger to himself and others.
Okay, well, I mean, that's a great question, right? Because really what we're getting at are what are some of the less restrictive alternatives to guardianship? And so without knowing a lot more about what sort of risks you're thinking about, it's really hard for me to answer that, right? But there's a lot of alternatives to guardianship. One is that your state may allow for limited orders in lieu of guardianship. Maybe there's a particular decision that needs to be made, that there is not advanced planning in place that would allow that particular decision to be made. Maybe a targeted order would meet that need without imposing a guardianship. Maybe this is financial. Maybe something as simple as auto pay might address the issue. Maybe maybe the person has the capacity to appoint an agent. Maybe the primary source of funds is public benefits, and a VA fiduciary or representative payee could take care of that issue. I think one of the reasons we see full guardianships remaining the norm is that people say, well, it's a progressive illness and it's just going to get worse. So why wait for disaster to strike? Let's do it now. And I'm sympathetic to that, but what it is so consequential and so limiting to an individual that it's really problematic. And so at the very least, thinking about, well, how might I craft, if we're going to go for guardianship, what do we really need? And so, for example, a lot of times guardianship is sought because somebody has substantial resources and there's a concern about dissipating, a lot of money, right? In those cases, allowing the individual to manage a small sum, and what's small is dependent, may have absolutely no substantial risk and be the difference between a high quality of life and a really meager quality of life. So really thinking creatively about, okay, what is it we're really trying to protect against? And to the extent that you're requesting a guardianship or a conservatorship, limiting it to that thing you really need.
Great. Okay, this next question is, the person has written a very long paragraph, and I'm going to try to present the nugget of it without reading the whole thing. I think the point of their question is, it says, if a petition for incapacity argues about exploitation, but the examiners examine and report on health, food, nutrition, etc., shouldn't there be a motion to strike or limit absent amended / supplemental pleadings? I think their point is, if a petition only alleges certain types of diminished capacity, shouldn't that limit what could actually happen in the court case?
Well, remember that ultimately what's going on in a guardianship case is the state using the state's power to impose a state restriction on an individual. And so I think actually one of the problems we sometimes see with the guardianship system is that sometimes courts think of this as just two parties fighting against each other, and it's more of a referee model. And that's not what guardianship is. This is the state coming in and removing rights. And so the court in a guardianship proceeding actually has a little more freedom, which can be used for good or bad, than in your typical court proceeding. And it's one of our challenges, I think, in reforming guardianship is helping courts understand that they're not a referee here. They're the primary actor, and they have a tremendous responsibility to do that. I will just say about, if the concern is exploitation, then perhaps the appropriate response is not to limit the rights of the victim, but to try to get at what's going on with the person engaging in the exploitation. And one thing you might want to look at if you're interested in law reform in this area is Article 5 of the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. I know it's a mouthful. Which creates an option for a limited targeted order to essentially excise the exploiter from the individual's life without restricting the individual's own rights beyond that removal.
Great, thank you. And I think we are out of time for questions. So
Thank you so much.
I'm turning it back over to Andy. Thanks.
Great. Thank you, Nina and Naomi. It was pretty much everything we had hoped for in terms of providing both the big picture of the import of these issues and the micro question about how these impact individuals and older adults, and why we need to give this much more thought and approach these issues much more thoughtfully. With our remaining time, I just want to mention a couple of things. One is just to invite you all to return tomorrow. Tomorrow we'll be focusing on the criminal context and how capacity issues arise in the criminal context. It was already touched upon by the clinicians panel, but will be discussed in much more depth tomorrow. Another thing I want to mention is the fact that after today, you're likely to receive an email with asking you to do an evaluation. You can ignore that from email today. You will receive another one at the end of the entire symposium, and that one we do hope that you take the time to complete. We want your input. The chat room discussions have already been vibrant and robust and an incredible source of information, but we do want to know what we did well and what we can do better. So when we do this again, we'll have the benefit of your input. I have a long list of folks to thank, but I want to do that tomorrow morning when there's everyone's back online. So with that, I would just say thank you for your attention today and for taking the time and investing the time to think about these important issues. And we look forward to seeing you tomorrow. Thank you.